Okay, here's the deal. You may not know this, but the term domestic terrorism didn't even have a legal definition until 2001. But somehow, over the last 25 years, it's been used so commonly when it comes to talking points about things and events going on that it just seems to be like everybody's supposed to know what it means.
It was an act of domestic terrorism?
Domestic terrorist.
Threat of domestic terrorism.
Yeah, I'm not sure any of them know what it means. So today, in this video, let's unpack this relatively new abstract legal term, including the history and how we got here, and then let's apply it to a few modern examples to see actually what is going on out there. What is domestic terrorism? I'm Jake the Lawyer, and welcome back to Internet Esquire. Okay, definitions. If you had to give me a definition of domestic terrorism, what would you think of? Mass destruction within America? Political mayhem? Assassinations? Yeah, I mean, all of those things tend to fall into the definition, but here's where it actually stands within federal law. Quick disclaimer, well, there are 32 or something like that states that have their own definition of domestic terrorism. I'm gonna stick generally with the federal definition because most of the states follow the federal law. Okay, so the definition comes from 18 United States Code 23315. The term domestic terrorism means activities that A, involve acts dangerous to human life that are a violation of the criminal laws of the United States or of any state, that appear to be intended to either intimidate or coerce a civilian population, to influence the policy of a government by intimidation or coercion, or to affect the conduct of a government by mass destruction, assassination, and/or kidnapping, and occur primarily within the territorial jurisdiction of the United States. Okay, well, let's compare this with the definition of international terrorism, because as we'll see, the definition of domestic terrorism is sort of just built right on top of that structure. Comparing the definitions, there are obviously a few elements in common here. It has to be a dangerous or a violent act that's already criminal in nature, and it needs to be intended to intimidate civilians or coerce government policy or action. And that's it. While mass destruction, assassination, and kidnapping are all mentioned within some of the definition, they are not required to actually meet the definition. So the only real difference that separates domestic from foreign terrorism or international terrorism is the idea of where it occurs. Okay, legal definitions are great and all, but they don't really tell us anything. They're only just useful when they're useful, and they don't really give us the context for why the definitions are written this way in the first place. In order to understand that, we have to look at how terrorism law as a doctrine originated into American law. One common misconception when it comes to terrorism law is that there is no standalone criminal charge, at least before the federal law, when it comes to domestic terrorism. Not in the same way that we would think of crimes like burglary or murder or arson. There was never just a federal crime called terrorism or domestic terrorism, and there still isn't today.
Hey, terrorist! Terrorize this.
And while there are some states who have adopted that as a chargeable offense, that still doesn't exist within federal law. So let's just stick down that road. Instead, the idea of terrorism as a category within American law began as a patchwork and grew over time into a doctrine that today places specific crimes within a specific category. There is always some specific underlying crime, such as murder, arson, burglary, etc., that the person or the terrorist is charged with, and gives the government specific legal powers to prosecute and sentence those crimes differently than how they would when they are outside of the category of terrorism. And the reach of what is or could be a crime, even before acts of violence, is typically greater in terrorism law than in other areas of the law. Now, the word itself, terror, comes from the Latin terrere, which simply means to frighten. But it wasn't until the late 1700s with the French Revolution and the Irish Rebellion of 1798 where the term terrorism began to be used when directly talking about political acts meant to intimidate or coerce that are typically violent and criminal in nature. Now, bringing that idea over into American law, it wasn't until the late 20th century where we actually began using the term terrorism in a legal, or at least in a quasi-legal construct. And it wasn't until 1990 when the definition of international terrorism was actually written down, and not until the Patriot Act of 2001 when the definition of domestic terrorism was written down. And just like the Patriot Act of 2001, the place where it all began was with airplanes, or for the most part. Beginning in the 1960s, airplane hijackings began to become a defining national and international security issue. In fact, there is almost no way to overstate this. Between 1968 and 1972, airplane hijackings globally were happening roughly at a rate of once every 5 days. I'm not making that up. I fact-checked it. I math-checked it. Oh yeah, every 5 days somebody hijacks an airplane. Look, it's really not that big of a deal. I mean, this is insane to think about in today's context. And it is for this exact reason that if you're a millennial or older, the moment that you hear the word terrorist, you immediately think of some crazy guy with a gun stealing an airplane.
Get off my plane.
That's literally what was happening in the late 60s and 70s. I mean, there is an entire video itself that could just be dedicated to airline hijackings, but let's stick down the domestic terrorism path. How did this lead to domestic terrorism? Well, in the beginning, believe it or not, most hijackings were non-violent. Beginning with the Cuba embargo, between 1960 and 1974, there were something like 160 American airliners that were hijacked, and 85 of them were by Cubans or Cuban Americans who were rerouting those flights to Cuba because they could no longer leave America and get back to Cuba. And for the most part, these were non-violent. Still political, but bloodless, they were called. So the legal response by Congress to this problem was pretty straightforward. They just made airline hijacking a federal crime. Done, right? No. So throughout this time, because most hijackings were non-violent, the policy of the airlines and law enforcement at the time was to simply give the terrorists, or the people who had stolen the plane, what they wanted and avoid loss of life. The reason for that is because they didn't want to deter people from flying. They didn't want to drive down business, and they were like, hey, you know, you get diverted to Cuba every now and then. It's a totally manageable, acceptable risk of our business. You get a nice little vacation, you get a Cuban cigar, we pay for your airline ticket. Look, we even give you free flights on the next one. Okay, think about it. How many Americans have been to Cuba? You're lucky. You're actually lucky. Anyways, this policy led to a problem though, because when criminals commit a specific crime and then they get exactly what they're looking for as a result of committing that crime, incidents of that crime don't go down, they universally increase. And that's exactly what happened with airplane hijacking. And like I said, while most of them at the beginning were non-violent and not that political, over time, they became more political and more violent. By the 1970s, violent acts involving hijacking airplanes for political coercion had unfortunately become very common. Now, I poured through dozens of these examples from the 60s and through the 70s, and outside of the just take me to Cuba examples, the majority of the other ones involved Palestinian militant groups hijacking airplanes and then using the passengers on board as political bargaining chips to get militants that were in prison somewhere else in the globe out and to attract international news attention onto their cause. But there is one prime example out of all the examples I looked at that highlights just how violent and just how international these hijacking incidents had become. And it happened in 1976 in Entebbe, Uganda. The Popular Front for the Liberation of Palestine, which was already a Palestinian militant group that had become notorious for hijacking airplanes in the past, collaborated with a German Marxist group to take over a flight from Tel Aviv that was stopped over in Athens. Well, they divert the flight to Entebbe, Uganda, where they're met on the ground by about 100 Ugandan ground forces, not there to stop them, but there to support them with direct authority from President Idi Amin, the president of Uganda at the time. After releasing most of the non-Israeli passengers on board, they left the Israeli batch and a few others, and they held them there to use as a bargaining chip against the state of Israel because they wanted to exchange out militant Palestinians that were being held in prisons there and in something like 4 other countries. And after about a week of trying to use diplomatic measures, the Israeli government decided to send in a commando force. Now, I'm going to do an entire video on this, I think, in the coming weeks, but just to summarize it for the purposes of this video, here's what happened. The commando force shows up, and they had originally thought that they were going to get through security with a black Mercedes surrounded by a bunch of Land Rovers, which is how Idi Amin used to drive around. But when they got to the sentry gate, they realized they couldn't get through because the guards knew that Idi Amin had changed from a black Mercedes to a white Mercedes. So what did they do? They just executed the guards with suppressed pistols, and they drove into the airport. Well, pretty much from that point, the bullets started whizzing. Armored personnel carriers were dropped out of C-130 airplanes that landed on the tarmac. The commandos blew up 11 Ugandan MiG fighters that they had gotten from Russia. They then rescued the hostages and in an intense open running gunfight, shot back and forth at Ugandan ground forces, some of whom were in a control tower, and when they shot back at the control tower, they did so using RPGs. 45 Ugandan soldiers were killed, including 7 of the actual hijackers who were there on the scene, including the Israeli commander who was commanding the ground unit.
That escalated quickly. I mean, that really got out of hand fast.
Anyway, I use this example to simply point out this wasn't just about taking over a flight and diverting it somewhere, as bad as that already is. No, this was full-blown terrorism. This was dangerous and violent acts that were crimes in other countries. This was state-sponsored, or at least state-supported. And this was done to intimidate civilian populations and coerce government policy. And again, the Entebbe Raid was just an example over the course of this era to show you how violent things could become. So a couple of interesting things developed within the law that are sort of quintessential to terrorism law that didn't exist before. Terrorism becomes a sort of uniquely federal area of law, and terrorism jurisdiction itself seems to cross outside of the boundaries of the United States, even though the law is originating from there, and reach into other parts of the globe. And in 1969 and 1970, there were 2 international treaties signed that came out of the Tokyo Convention and the Hague Convention, designed to get a common understanding between international governments on how to deal with these types of terrorist incidents. And US Congress, along with the other member nations, were forced to recognize this sort of extraterritorial jurisdiction within their own national laws and across the other nations' laws if they were all going to agree to this treaty. So as a result, Congress wrote and amended core portions of the aviation law. And here is a core example. The definition of airline piracy, which is stated in 49 U.S. Code 46502. Seizing or exercising control of an aircraft that is in the special aircraft jurisdiction of the United States by force, violence, or intimidation. Now, when you look at this sentence, are there any words that sort of exist out of the ordinary here? Well, if you're a lawyer, I hope something does. Special aircraft jurisdiction of the United States? What is that? And the penalties for violating this law were strict: imprisonment for at least 20 years, and if someone died during the incident, they could seek the death penalty, and you could get a much longer sentence, longer than 20 years. This is exactly what I'm talking about. This is the law attempting to meet what was agreed upon in these international treaties and meet this new threat that had never existed before. And because of the unique international nature of air travel, going across borders and crossing over international waters and all of the above, they had to create some kind of special jurisdiction that didn't exist before. The idea is that each nation has a right to prosecute crimes that happen in flight, so long as that flight has passengers or planes that are tied to that specific nation, even if the crimes occurred over international waters or over a foreign territory. In a sentence, this is the legal seedling of how all terrorism law was planted into the doctrine of American law. And as you can see from the beginning, it had this extraterritorial nature to it, something that was uniquely federal and that carried with it incredibly strong punishments. So knowing that, and knowing where terrorism law stands today, you can begin to see the notion of how one grew into the other. And then on December 21st, 1988, Pan Am Flight 103, which was a Boeing 747 carrying 259 people and 159 Americans, departed London's Heathrow Airport, headed to New York City. And 38 minutes into the flight, over Lockerbie, Scotland, a radio cassette player that had been turned into a bomb exploded, killing everyone on board, as well as 11 people on the ground who were struck by debris. Following a 3-year investigation led primarily by Scottish authorities and the FBI, finally in 1991, arrest warrants were issued for 2 Libyan nationals. However, it wasn't until 1999, 8 years later, when under pressure from the United Nations, Libyan dictator Muammar Gaddafi actually handed over the Libyan intelligence officers who were listed in the warrants. And it's pretty clear that this was another incident of state-sponsored terrorism, because in 2003, the Libyan government formally accepted responsibility for it. And in 2011, a few months before Gaddafi died, a Libyan justice minister admitted that Gaddafi himself had personally ordered the attack. The wild side note of the Lockerbie bombing of 1988 is that somehow this case is still going on today. In 2022, the United States received some other guy who was involved in the bomb making, and we're still holding him in custody, and he's expected to go on trial this year. Either way, the most important thing that came out of the Lockerbie bombing for the purposes of terrorism law was that in 1990, US Congress passed the Aviation Security Improvement Act. The act took the concept of things like the special aircraft jurisdiction of the United States and ran it down a path where the language begins to look a lot like what we see around 9/11. Here's what I mean. In 1989, newly elected President George H.W. Bush visited with the victims' families. By August, Bush had established the Commission on Aviation Security and Terrorism. The job of the commission was to evaluate U.S. security and aviation protocols with respect to terrorism as a general threat. And after about a year, the commission found the sabotage of Flight 103 could possibly have been averted if proper security safeguards had been in place. Intelligence operations were fragmented among individual airlines and several agencies, and technological research and development of counterterrorism devices lagged behind actual terrorist activities. As a result, the final report of the commission had 64 recommendations to government. The U.S. State Department, not American aviation companies, should be the aviation leader in international security matters. The FAA should partner with the FBI in assessing all domestic aviation threats. Commercial airlines must report all security threats to the FAA. The FAA should plan and implement additional security measures into domestic aviation over time. And here are a few interesting ones. Terrorist acts must not be allowed to disrupt U.S. political and economic interests. State-sponsored terrorism and safe havens for terrorists must be identified and isolated through international cooperation. That's starting to sound an awful lot like 9/11. The U.S. must actively punish state sponsors of terrorism and safe havens for terrorists. I can see George H.W. looking at his son W. and being like, "Son, when I was CIA director, we came up with these policies and then I implemented them as president, and I have given them to you. You may take them now and execute the will of the United States upon the globe." The commission also recommended these punishments should include preemptive or retaliatory attacks carried out directly or covertly. And philosophically, the national will and the moral courage to use it is the ultimate means to defeat terrorism. Tell me that doesn't sound like 9/11 rhetoric, and I'll buy you a car. I'll do it. So what happened from here? Well, the commission issued its final report, and then it introduced this as legislation to Congress in 1990. And the bill, the Aviation Security Improvements Act, passed with nearly every single recommendation that the commission had made. As a result, Congress stopped looking at the specific crimes that terrorists commit, like hijacking, and they started to look at terrorism as a doctrine, looking at and framing terrorism as a general threat. So with that in mind, the aviation industry began to redesign the entire security framework and do it in collaboration with federal agencies. And it was at this moment that the definition of international terrorism entered American law. And then the attacks began to hit the American homeland, with 1993's World Trade Center bombing and with 1995's Oklahoma City bombing. Now, at this point going forward, I won't get into the specific conspiracy theories that are associated with all of the things that I'm about to talk about. I'm just going to talk about the official narratives because we're talking about the official law, and I think these things make sense. I'd love to talk to you about them in the comments, though, so leave a comment about what you think. Here we go. February 26th, 1993, a rented van is driven into the basement of the World Trade Center with a 1,300-pound bomb inside of it, and kaboom, it goes off, it kills 6 people, and it injures hundreds more. A group of foreign-born Islamic extremists had planned the attack, and it wasn't just to blow up a bomb inside of the World Trade Center. The original idea was to bring down both towers, and they were doing this as a direct response to the United States foreign policy support of Israel. 6 individuals were eventually convicted for their direct roles in the attack. 2 years later, on April 19th, 1995, a rented Ryder truck is parked in front of a federal building in Oklahoma City, and at 9:02 a.m., boom, another huge bomb goes off, this time killing 168 people and causing structural damage not only to the federal building, but to a bunch of buildings nearby. This time, a group of domestic American citizens had planned the attack in retaliation for the federal government's involvement with the Waco siege and the Ruby Ridge standoff, which had happened just a few years earlier. Again, I'm not going to go into everything about this. I know you're out there and I see you, but we're talking about terrorism law, so let's just stay on that road, baby, okay? Because otherwise, this is a series that never ends. In fact, if you want to see me talk about conspiracy theories and dive deep into those, check out the Man vs. Morning podcast, where I sit down with two of my friends, Nolan and Tackett, and we get into all kinds of nonsense about this. It's a good time. It's not very family friendly, though, so if you watch this channel with children, don't watch the Man vs. Morning podcast. But if you're with the boys or you're at work or something, it's a funny podcast to listen to. I highly encourage it. Link in description. Anyway, after the World Trade Center attack of 1993 and the Oklahoma bombing of 1995, Congress passed the Anti-Terrorism and Effective Death Penalty Act of 1996. And the point of this act was to simply state that if we are waiting until after the bomb goes off, then the law itself is ineffective. The actual legal and cultural realization that came out of these attacks was that terrorism often is not just an isolated person, it's a networked enterprise. And the most important actors are not necessarily the ones that pull the trigger or push the detonator. The people who fund it, equip it, and provide material support for the act are also just as guilty, and we need to be able to go after those people too. So in response, Congress added the material support concept into the statutes of terrorism law, specifically 18 U.S. Code 2339A and B. Whoever provides material support or resources, knowing that they are to be used in carrying out terrorist crimes, it then literally names a bunch of prohibited acts and statutes surrounding terrorist crimes, shall be imprisoned not more than 15 years, or if anyone dies as a result of the act, for any term of years or for life. This act allowed federal law enforcement to go after terrorism before the actual violent act and to attack the supply chain of terrorism. But the Anti-Terrorism and Effective Death Penalty Act didn't stop there. As the name implies, it was also intended to make the death penalty more swift for those who had been convicted of acts of terror.
We used to be a proper country.
AIDPA tightened certain habeas corpus rules, which limited post-conviction petitions in death penalty cases. In English, this means that people convicted of the death penalty for acts of terror couldn't sit there and, after conviction, make more and more petitions, which effectively just delayed the death penalty by filing more paperwork. And AIDPA did one more thing that had never existed before, which is where the distinction between domestic and foreign terrorism begins to butt heads later down the line. It created the legal architecture for a formal terrorist group list. Federal law enforcement was now allowed to designate groups as foreign terrorist organizations, or FTOs. It allowed federal law enforcement to prosecute anyone who was providing material support to a designated foreign terrorist organization. However, because of the Constitution, this cannot apply to domestic terrorist organizations, which we'll get more into at the end of the video when we talk about President Trump's executive order establishing Antifa as a domestic terrorist organization. We'll get to that. For now, FTOs. What's weird about this is that it came out after 2 incidents of terrorism that happened on U.S. soil, one of which was wholly domestic, led by American citizens and done here. So you might be thinking, well, what does this have to do with the expansion of international terrorism law? Wouldn't this focus more on domestic terrorism? The reality is that it really didn't matter all that much. Politically, after 1993's World Trade Center bombing and after Oklahoma City, the appetite to provide preventative tools was much, much stronger. Congress wanted to give federal law enforcement ways to intervene with terrorist activity, and the way to do that was to simply build around the areas of law that were already sort of established. This is where the conspiracy theories start to come in, but more on that in Man vs. Morning. And this is why I'm always warning about blunt force instruments used to solve razor blade problems. Because Congress, being what it is, will just pass laws if there is a political appetite for them, even if those laws have nothing to do with the actual thing that brought about the appetite. Anyway, there was one more thing that came out of Oklahoma City. The term domestic terrorism entered the American lexicon for the first time. All right, then we get to September 11th. Everybody knows what happens, or, well, at least what we think happened.
Somebody in here?
Not gonna go down the road, not doing it. Here's the official narrative of what happened. 19 hijackers, 15 of them Saudi Arabian, and all of them Islamic extremists, take over 4 airplanes. Well, at least 2 airplanes were involved. 4 airplanes probably. 2 of them fly into the World Trade Center's North and South Towers. 1 of them flies into the Pentagon, and 1 of them crashes in a field in Pennsylvania after it was intended for the US Capitol. Either way, 3,000 people died, and it was the deadliest attack on America ever, more so even than 1941's Pearl Harbor. It sets off the global war on terror, otherwise known as GWOT, and the US government dives fully into finding and destroying whoever was responsible.
We will make no distinction.
As well as preemptively destroying anyone involved who might be also doing terrorism or providing material support. To meet this effort, or at least that's how the story goes, US Congress passed the USA Patriot Act on October 26, 2001. As a general concept, the Patriot Act was a massive overhaul of federal surveillance and investigations, with the stated intention of making it easier to prevent, investigate, and prosecute terrorism. To do this, the Patriot Act removed walls between federal agencies and law enforcement agencies, and expanded tools to track communication, financing, and networking of terrorism. While the Patriot Act did add the legal definition we have today of domestic terrorism, it did not create a standalone crime of domestic terrorism. Instead, it changed the way that federal law enforcement handled crimes that now, based on the facts, fell into the new definition of domestic terrorism. Here's what I mean. If any underlying crime, hijacking, murder, whatever, fell into the definition of domestic terrorism, then federal law enforcement could now identify, investigate, classify, prosecute, and sentence that crime through entirely different legal pathways than it could otherwise. Federal agencies now track domestic terrorism cases as a category because it tells them what kind of case it is, what resources to use, what task forces to run through it, how to coordinate with local law enforcement, and how to report it. They also prosecute these crimes differently. Even if domestic terrorism isn't the crime stated in the criminal count, the same facts that make something domestic terrorism also probably make that criminal count stronger, or proving that criminal count stronger. If you wrote a manifesto, made threats, picked a specific target to send a political message, all of those things are going to be considered and can support the underlying criminal charges. And lastly, crimes deemed to be domestic terrorism receive much harsher punishments than the same crimes that are deemed to be non-terrorism acts. Interesting side tangent here. Here's how this works in federal sentencing. After someone is convicted of a crime found to be a federal crime of terrorism and therefore meet the definition of domestic terrorism, the sentencing judge has to calculate the criminal sentence under specific terrorism enhancement guidelines. And within the judicial branch of the federal government, there is an independent agency called the United States Sentencing Commission. The USSC is responsible to give sentencing guidelines to all of the federal courts within the federal system. And the manual on these guidelines is known as the United States Sentencing Commission Guidelines Manual. I know it's very innovative. Well, within this manual, there is the General Law Application Principles and Procedures, otherwise known as GLAP. And GLAP Section 3A 1.4 lays down the actual sentencing guidelines for someone who has committed a crime deemed to be a federal crime of terrorism. I wish I was kidding. This is how it works, people. And I suppose this kind of makes sense given that there's so many federal courts, and the judicial system's job, in part, is to make sure that criminal sentencing is consistent and predictable across all of those courts. So it makes sense that you'd kind of write a guideline, but doesn't this seem like it's just gone a little bit too far, like all things with the federal government? It's just, guys, we just want to be left alone. Anyway, within the GLAP guidelines, if you are found guilty of a crime deemed to be a federal crime of terrorism, your offense level jumps by 12 to a minimum of 32. And your criminal history is automatically set to a category 6, which is the worst. Level 32 offenses carry prison sentences from 210 to 262 months. That means your bunkmates will be a serious drug runner, a bank robber, and somebody else who has committed at least 2 pretty bad felonies. But Congress didn't just stop here, because why would they? About a year after the Patriot Act was passed, they also passed the Homeland Security Act, which established the Department of Homeland Security. And for those of you who don't know, establishing the Department of Homeland Security was one of the largest redistributions and consolidations of federal law enforcement and federal power since the establishment of the Department of Defense after World War II. You combine the consolidation with the Homeland Security Act, with the expansion of agency power under the Patriot Act, and suddenly terrorism is no longer some temporary emergency threat response from the federal government. Terrorism prevention now becomes an industrial, standing function of the federal government in a way that never existed prior to 9/11. Taken all together, the events and statutes after 9/11 and leading up to it overall create the terrorism legal construct that we see in the law today. Now, the full effects that this shift in federal function will have on American society, I mean, you could fill volumes and volumes of videos with just this topic alone, and who knows what this will look like in 50 years. The point is that after 9/11, most of the rhetoric, thought, and application of this new terrorism doctrine was pointed outward. Post 9/11 terrorism law was never really about taking that law and then turning it inward on the American people. And yet, as the global war of terror began to wind down, we saw increasingly counterterrorism tactics begin to slowly make their way homeward. We've seen an uptick in the use of the word domestic terrorism being turned on acts that are happening here at home more and more. And the strange thing that I don't think anyone intended at the time that these statutes were passed in the early 2000s was that domestic terrorism now, at least when you look at it against the definition, starts to look more and more like a protester throwing a rock at a federal agent. Violent act, criminal in nature, intended to coerce government policy. And to be fair, this slippery slope is a lot of what certain people were trying to warn us about when things like the Patriot Act and the Homeland Security Act were passed back in 2001 and 2002. And this is why I keep going back to the blunt force instrument for a razor blade problem analogy. We saw effectively the same thing happen when the 16th Amendment was passed and it brought on the federal income tax. Not that we were trying to stop terrorism then. What I'm saying is that we had a very specific problem, but we passed language that was so broad, 20 years later, it ended up being applied in a way that nobody ever intended at the time it was passed. And you can't look at terrorism law as a doctrine that developed and seeing where it's at today and say that at least some of that didn't happen, because it kind of feels like a lot of bit of that happened. Anyway, I think that's enough context and history. I think the best thing we can do at this point in the video is turn our attention to how does this apply now? All right, this is a big one that came up last September. President Trump issued an executive order, which is not an actual change in law, but a directive within the existing presidential power, to designate Antifa as a domestic terrorist organization. There were primarily 2 key issues that came up as a result of this. Number 1, is this the same thing as a foreign terrorist organization? The short answer to that is no. Designating Antifa as a domestic terrorist organization does not immediately apply the same laws as would be if it was a foreign terrorist organization. Effectively, this executive order changes the posture of how federal law enforcement treats Antifa. And we know this because immediately following the executive order, the Department of Justice issued guidance pushing more cases involving Antifa into a terrorism-style handling. This means things like directing more cases to the Joint Terrorism Task Forces, encouraging aggressive charging of cases, and ordering the FBI to compile and regularly update a list of groups and entities that may constitute domestic terrorism. So while the executive order did not magically create a domestic terrorist organization in the same way as an FTO, there were certainly real-world changes that happened as a result of the order. But if we separate all that for a second and we just look at this through a political lens, its purpose begins to be a little bit more clear. Presidents from either party across time have done this all the time. They'll issue some kind of an executive order, and then congressmen and representatives argue about either side, and then they start to introduce legislation on it. So the fact that we're potentially moving in this direction now of designating domestic terrorist organizations, big oof. There's big oofs going on. First of all, why is there no domestic terrorist organization list? And the primary reason is the Constitution. The freedom of assembly, the freedom of association, the freedom of speech, the freedom of protest and to petition the government for redress of grievances, all very much at issue here. It makes listing any domestic group as a terrorist organization immediately suspect before the law. So even if Congress did pass a law like this, it would probably immediately be struck down by the courts. And in support of this, both the FBI and the DHS have issued guidance to everyone that works there and all the other agencies saying, hey, investigations into individuals, even if they are part of extreme fringe groups, cannot be based solely on First Amendment protected activity. Now, obviously, if there are acts beyond First Amendment protected activity, such as trying to burn down buildings or start violent riots, well, now you're talking about a different thing. But you can't tell somebody that they're a terrorist and prosecute them for it just because they talk like one. But the more honest answer when you're talking about it from a law enforcement perspective is that we don't need a domestic terrorist organization list because the laws we already have now are sufficient. And this is basically what the RICO statutes are, passed in 1970, the Racketeering, Influenced, and Corrupt Organizations Act. It was designated specifically so that federal law enforcement could go after organized crime in a way that extends past individuals and to the groups that those individuals are associated with. And combined with the severe issues that any type of law in this direction would cause with the Constitution and the First Amendment, I don't think we're going to see any serious motion in that direction anytime soon, if at all ever. All right, January 6th, 2021, everybody remembers the act of insurrection, or at least they put it on daytime TV for people to watch for like a year. The January 6th trials. Anyway, this was a big one where the word domestic terrorism got thrown around a lot. So let's just ask the fundamental question. Was the storming of the Capitol on January 6th, 2021 an act of domestic terrorism? Well, it kind of meets the definition when you put it into context. Acts dangerous to human life, which is intended to coerce government policy. You see what I'm getting at? The funny thing was, the Department of Justice Attorney General at the time was always very careful with his wording to not call it that specifically. He would always call it an attack on the Capitol. Now, I believe a person did get stampeded. Somebody was shot trying to get in through a window, and there was a bunch of people who had like heart attacks and strokes. So to look at it as a whole, it was very easy for media at the time to look at it and go, that's an act of domestic terrorism, because it sort of, kind of, somewhat fits the definition. But then you get into the whole charging aspect of it, where you're talking about, okay, who is being charged with what? And is that crime, the underlying crime, a federal act of terrorism? And to be fair, when they were prosecuting people as a result of January 6th, they did do this for some very specific people. As far as I can tell, there were at least 2 members of the Proud Boys who, when they had their sentencing hearings, were charged with sentencing enhancements as a result of the terrorism laws. However, the government tried this action several times with several other people as well, and several other times in those instances, sentencing enhancements were rejected. So Again, you get into this weird gray area. But separating all that aside and just looking at, did this event meet the definition of domestic terrorism? I think it leans in that direction. All right, and since we've gotten this far and we're this far into the video and we have all this knowledge now, let's think about the Minneapolis woman ICE shooting that happened a little bit ago. A woman was shot driving at or away from ICE agents as they were beginning to attempt to detain her. And she did make contact with her vehicle on one of those agents, and that agent fired upon her and she died as a result. But the thing that everyone remembers is that that same day, Secretary of Homeland Security Kristi Noem calls it an act of domestic terrorism.
You asked about a shooting that we just had in Minneapolis, Minnesota. It was an act of domestic terrorism?
And this is where you get into the slippery slope of just calling everything domestic terrorism. You're domestic terrorism, and you're domestic terrorism, and you're domestic terrorism. Look, does this meet the definition? Again, let's examine it. An act dangerous to human life. Okay, yeah, hitting somebody with a car, even if you're trying to get away, is an act that's potentially dangerous to human life. Is it criminal in nature? Yes, you're evading law enforcement. And does it appear to be intended to influence government policy? Well, why was she there? Now, personally, I think that calling that specific instance domestic terrorism is a bad take, but also it kind of does meet the definition, doesn't it? That's my point. That's not me defending her. For the record, I think she was a classic definition of a useful idiot. I'm just simply saying, look at the road we're going down. And obviously you can examine this incident 6 ways from Sunday, as everybody did for 2 weeks afterwards. I'm simply trying to point out our main concern right now should be looking at law enforcement and going, how many times are you guys going to use that? And how do you plan on using that? Because that could be very problematic for everybody. Because suddenly now, anything that could potentially be construed as dangerous in a manner that is criminal in nature, involving any form of political protest, is now an act of domestic terrorism. That is a problem. And I think we can all agree on that. Because legally, that's a nightmare nobody wants to be a part of. So there you have it. That's domestic terrorism in a nutshell. I hope you learned something. I thought the history part was the most fascinating when I was doing the research on this video, because you can see how terrorism as a doctrine originates, and then it quickly goes into this thing that we have today. And that I found to be fascinating. So I hope you learned something. Thank you for watching this far in the video. I got new lights in this video, and I'm gonna be having a new camera coming soon. So thank you very much for your support. It has encouraged me to make more videos. Thank you for the comments below, suggesting new topics for me to do. I very much appreciate those. And if you've watched more than one of this video, consider subscribing. If you're into some humor, consider checking out the Man vs. Morning podcast. And I will see you later. Have a wonderful day. Ah, my microphone. I left it on.